Не хвилюйтеся. Я тут, все нормально, не хвилюйтеся.
Так, можу тебе перекласти?
Добре, давайте. Okay, so I'm here and I'm glad to see you in our virtual classroom. So my name is Katerina and I am in charge of international cooperation with our guest professor.
Шановний пане Фабріціо, хочу передати вам, перш за все, вітання від ректора Державного податкового університету Дмитра Миколайовича Серебрянського та директора Навчально-наукового інституту права Василя Васильовича Топчія. Вони б хотіли сьогодні бути присутні, але, на жаль, не змогли. Обіцяють приєднатися в наступній лекції.
Dear Sir Fabrizio, I want to share greetings from our rector, Dmitro Serebryansky, and director of the Educational and Scientific Institute of Law, Topchi Vasil Vasilovich. And of course, we are really glad to hear you and provide your lectures.
Пане Фабриціо, хочемо подякувати вам за те, що зголосилися прочитати нашим студентам свій курс з основ міжнародного права. Взагалі зголосилися поділитися вашим досвідом як науковець, як практикуючий юрист Італії.
We are really pleased that you decided to conduct lectures as a guest professor and to share with you great experiences that will give a great opportunity for our students. Thank you very much.
Маю підкреслити, що програма вашого курсу одразу, як тільки з'явилась на сайті нашого університету, викликала величезний інтерес. Про це свідчить кількість зареєстрованих на курс. Впевнена, що наші студенти під час цього курсу отримують великий обсяг нової для них інформації, яку зможуть використати в навчанні і в подальшій професійній діяльності, особливо наші майбутні юристи-міжнародники.
Your program is extremely popular among our students. So when it was published on our Facebook page, so it has a great popularity. So you even can see. So we have a lot of participants in our virtual classroom. And we also hope that your knowledges and your material from your lectures will help them to be a great lawyers, especially in the field of international law.
It's my turn?
Yes, yes, of course.
Okay. I thank you.
Хочу забирати багато часу, хочу побажати.
You tell me when I can speak.
Okay, okay, thank you.
Перепрошую, поганий зв'язок.
Ага.
Не хочу забирати багато часу, хочу побажати плідної роботи, гарних цікавих лекцій. Тож, думаю, приступаємо до лекцій.
Okay, so Katerina said that she wishes us a good, productive work. So, and she also hopes that this lecture will make a great contribution into knowledges of our students. So, дякуємо, Катерина. So, Fabrizio, so now it's your turn. You may start.
Okay. I thank you, the Tax University, for this opportunity. I'm very happy to be here and to have the possibility to help the students to improve their knowledge. I'm really honored. I'm also a little nervous because it's my first time teaching in Ukraine. You want to translate for Katerina? Okay. Dякую.
Я дуже вам вдячна. Це для мене велика честь давати лекції для студентів податкового університету і взагалі працювати з українцями. Дякую вам, Катерина. Okay.
So I will try to do my best. Just I thank you in particular the students, because this is not an evaluative class, is a voluntary class, and it's make proud the professor to see so many people taking care. I attended and I teach at the ancient university in the world, the University of Bologna, that was created by the students, because the students came to Bologna, choose their teachers because they want to learn. So in my way of thinking, to have the trust and to have the attention of the student is the most important things for a teacher, for a professor, for anyone who had to share his knowledge. You can translate.
Я дуже вдячна, особливо студентам. Взагалі трошки екскурс з історії, що перший університет з'явився в Болоні, і саме туди прийшли студенти навчатися, і саме вони обирали собі лекторів. Тому, якщо студенти обирають, значить це великий плюс для викладача. І я, як викладач, дуже радий побачити таку велику кількість студентів на своєму курсі. Тим паче, що це добровільний курс.
Just few notes before to start. As I say, this is not a evaluative course, but I'm going to set it as it was, because this is the way I'm used to work. I will send you a personal format to be filled by the students, so I can know you a little better. It's very simple. It's about your age, your studies, what kind of course you already attended, and also your knowledge of English. Because here we have, let's say, a little issue in regards to the language, because none of us is English native speakers. We choose English as a language to communicate, but it's not easy. As a teacher, my first duty is to understand if the people attending my lesson are able to understand me, and do my best to be clear and let them make them be able to understand me. So that's why and touch matters that are really in the interest of the student. That's why I'll ask you to fill this format. I will also send you a format for question that you can fill after each lesson and send me back. So, and I can answer you privately, or if the question is particularly interesting, we can discuss it during the next lessons. But also this I think is important, because I should be in touch with you and know what you want to learn, what is important for your education, and I have to be sure to be able to explain myself in the right way. The course is divided in modules. Not each lesson is a modules. Probably it takes more lesson to make a single modules. After the modules is finished, I'll send you a PowerPoint in English based on my lessons, basically the script of my lessons, so you can read it, you can discuss it, you can also make additional question of that and additional research by themselves. Last note, we have this appointment online in every fourth Monday of the month. For next month in October, it will be always online. In November, probably I will be in Kiev, and I would love if we can make a lesson in person, at least with whom is attending regularly the university course there. Now I start my lesson.
Можливо, давайте я 3 хвилини перекладу, ну так, для них в загальному. Дивіться, що пан професор каже, що він, хоча цей курс дійсно для вас є не обов'язковим, тобто це за власним бажанням, але все ж таки у нього до вас є декілька вимог. Перша з них, він вам надішле анкету, в якій ви запишете, в якій буде питатися вас про ваш вік, і там основним пунктом також буде знання мови. В зв'язку з тим, що англійська у вас лекції будуть проводитися англійською іноземною мовою, і він повинен зрозуміти, на якому рівні ваша іноземна, щоб розуміти, чи ви його зрозуміли. Так, далі він також буде надсилати завдання, які ви повинні будете виконувати, і він вам буде давати фідбек. Наступний пункт, значить, у вас ці теми всі розділені на модулі, з якими він буде читати. І пан професор, значить, буде проводити ці лекції кожного останнього понеділка. Як ви бачите, зараз в вересні воно у нас онлайн, в жовтні онлайн, а вже в листопаді пан професор завітає особисто. So, thank you, Fabrizio. I will not interrupt you, so please start
Okay.
at last. Thank you very much.
Just one last note. In the future, I'm going to activate an email address dedicated to the student, and I will give it to you, so the student, in addition to the form for the question, can write me directly for additional information, suggestion, or questions, or whatever they want to share with me.
І ще один момент, я надам вам свою електронну пошту, на яку ви можете надсилати свої листи, надсилати свої записи, і через неї ми з вами будемо комунікувати. Окей, thank you.
Okay.
Okay.
I start with my
Yes.
lesson. Today we start talking about the fundamentals of international law, and I think the base to start is the definition of international law. The most simple definition of international law, the most basic definition, is the following. International law consists in a set of rules made by states in order to regulate the legal relation between them. Such rule belongs to a legal order shared by each of the members of the community of the state. This is not a bad definition. It's very useful and simple, but incomplete, because when you consider a legal order, especially the international law system, we have to consider not only the rules, but also the way these rules are created and enforced, as well the political and economical system that express the necessity for these rules and, on the last instance, push it for their creation. About this, I want to share with you a thought that I think is something that should be always in the focus of anyone is in touch with legal matters and want to proceed a career on the legal field as a lawyer, as a judge, as any other professor, and so on. The legal system are always connected with the reality of the world. It's not something that is separated from the world. It's influenced by politics, it's influenced by economics, is influenced by the historical situation and events. Is in this way on each aspect of the legal profession. It's in this way for the production of the laws. Is it this way even if you have to, as a lawyer, to draft a contract for a company? Because as the law should answer to the needs of the society, about the specific issue, about this specific request and need of the society, a contract must follow the needs of that specific client, of this specific company. There are contracts seems to be the most simple thing. You can go on internet, download the format, fill it, and send it to a client. It's not in this way. The right way to do it is know your client, whoever it is, or whatever it is, have a full knowledge of his environment, his system, his way to work, or, for example, if you have to deal with this matter, with his personal matters of his life, and then drafted, acted, or created something that is close to his life, is integrated on his life. That is, doesn't matter if it's personal or business matter. As we say, the definition that we already read means it's I read it again, is a set of rules made by state in order to regulate. This gives the impression of something, and such rules belong to a legal order shared by each of the members. This gives the impression that international law is something coming from above. It's something coming from, because is imposed to the state. And I think that the first step is to clarify this point. We are used to think, if we study law, we are used to think about the legal system in a certain way, because the first approach we have with law is the national system, the national law order. And so I'll make a little digression, and is creating a comparison between the national law order and the international law order to underline the difference. In the national law order of a single nation, we have a legislative body in charge to create the rules of law or laws. In Ukraine, it's the Rada. We have a jurisdictional body in charge of apply these rules of law. This is common in every country. There are the tribunals of each level. We have also a police force and correctional system in charge of enforcing the rules and the decision of the judicial body taken according to these rules. Among this, in some countries, we can include the bailiff and the court officer in charge of enforcing the court orders issued in the civil law cases, because in some countries is still the police force that enforce the court order. In other countries, for example, Italy, we have court officer that executed the order of the court, notified the order of the court, the claims, the starting of the cases that are different, have a different authority from a police force. Last, we have also in the national system, we have also constitutional court or a similar entity that is in charge to verify the compliance of the rules and the decision taken by the entities that we have mentioned to the basic legal principle on which the nation is founded, and usually included in the constitutional laws or similar level body of laws. So we have last element in the national law order, we have an entity that has to verify that everything what is produced, law or decision, are compliance with the basic principle of this nation. Because, let's say, this is the theory of the democratic states that any country should follow. But in theory, it should be a principle valid to everybody. In regard of another point that we have to examine in the matter of the national legal order are the legislative source. In regard of the legislative source and the hierarchy of the legislative source, in the national legal order, we have a constitutional law level. We have a national law level or federal law level. Depends if the state is a applies a federal system or not. For example, Italy doesn't have, they have regions, but we don't have a federal system. Germany, United States, we have a national, it's a federal, they have a federal system. So like we in Italy, we have, or in France, we have a national law. In Germany, there are federal laws. In the United States, there are federal law. We have a regional or state law level. In Italy, we have the law issued by the region in certain matters delegated by the state. For example, I use Italy because it's a system I know better, and maybe it's more simple. In Italy, for example, everything connected with the healthcare is delegated from the state to the region. The region are able to manage and issue regulation on the healthcare at their level. Same things happens in United States. In United States, there are some matters that are federal jurisdiction, so controlled by the central state, and some matters that are given to the jurisdiction of the single state. For make a very simple example, the rules regarding the sale, the transport, and the production of alcoholics. Basically, in each state has its own regulation in regards to regards of this matter, including the drinking age. When I was a kid of your age, sorry if I use kid, but I think it was a long time ago. One of the few states that allow the majority at 18 years old for drinking was Vermont. And during the weekend, you will see lines of cars of teenagers, 18, 19 years old, that they went to on a Friday night on Vermont to drink. That is because the air was allowed, and something that could be to do something that could cause a penalty or even a condemnation in the neighboring state, like New York or New Hampshire. Under the regional or state level, we have the country or provincial law level. So in certain legal orders, even the counties of the province, in Italy we have the province again, are able to issue law decrees in certain delegated matters from the state and from the region. For example, we have in Italy we have a kind of special system in the sense that we have some part of legislation delegated to the province, because before the region was instituted, we just have the local administration was all in the hand of the provinces. Then we have another law level, that is a small community. The city, the village, it can sound strange to you, but even decide if you can park or not park in a certain street or in a certain part of this street, basically it's a legislative action. The town administration take decision about this, allowing something or not allowing something, and in this case they create a small legislative level. Under, at the bottom, we have other laws like customary laws or natural or traditional laws. That is something that was before the legislation, but in this country, in this area, are still in use. In a few words, the national law order is very structured and a very organized system. It's like we imagine. It's like we studied when we started to study law in the university, or earlier if you started early. The international law order is very different from that. We have a multitude of different entities, each of them with own dignity, authority, and freedom to decide. Because we have states, we have entities that they have own sovereignty, they have own rules, they cannot, and they can, there is nothing that links them outside their desire to find an agreement on common ground to manage the interstate relationship. At the point of the international law order, there is no legislative body that has the authority to issue law and rules for everybody in the name of everybody. It's the same aspect. We have different entities which is on their own entity, their own authority. They didn't elect anyone. They don't have, and there is no, so there is no parliament that can give them, they can delegate the authority to decide the future and the way to live. We have someone can be objected that we have the United Nations, but the United Nations are a voluntary organization in the sense that a country can decide to join the United Nations or not decide. It can be rejected, but it's something that is voluntary. On the other side, when they try to decide what to do, they, the United Nations, they don't have in general an impositive power. They can recommend certain type of action. They can take resolution. But there is a principle that we will see today going on with the lesson, that is called the Westphalian principle, for which no one can interfere on the internal authority of each state. I'll explain you better in the future. But basically, not even the United Nations can interfere in the internal affair of a single state. There are several examples of this. For example, when there is a deploy of the blue helmet of the United Nations, the peacekeeper troops, they cannot be deployed without the agreement of both the nations that confronting each other or are at war. And this United peacekeeper cannot interfere directly, cannot act as a police force, and use also the limited use of force that they are allowed without the consent of the hosting country. This is, and there are a lot of, was a famous crisis in Congo in 1960. There were deployed the peacekeeping force of the United Nations. They were, at the time was the president of Congo, Patrice Lumumba, was assassinated and was killed, and there was a tentative of secession of part of the country. There was an intervention of the United Nations peacekeeper. They, at the beginning, tried to enforce a unification, and this created a lot of political problems for the Secretary of the United Nations and the organization. From that point, the United Nations were also very cautious how to use their forces and how to move it. And this was a case that from some part, the presence was requested, but this was not requested the action, because at a certain point, the United Nations troops take action against one of the parties. Other point, there is no judicial body that has the authority to judge everybody in the international law order. Someone can make an objection also in this, because there is the International Court of Justice. But I will dedicate some words to clarify the International Court of Justice in a few minutes. Because also the Court of Justice theoretically it's an international judgment entity, judiciary entity, but it has limits in its power. They are quite clear. Then, in the international law order, there is no police force or other type of enforcing authority on both criminal and civil cases. This is another point that we exploited deeply in one of the next lessons. The point is how it is possible to enforce the international law. But technically, it's not possible. It's very difficult. And I'll make an example before of the peacekeeper of the United Nations and the limits they have. Then, last point, in the international law order, there is no organized hierarchy of the legislative sources, at least not like we imagine it. Because that's another point that we will see. The source of the international law are various. Most of them are treaty and agreement, and each of them has its own, let's say, authority, its own dignity. So it's not easy to make a hierarchy of the laws and what is come first and what is bins a single state to do something or not to do something if there is two different there are two different treaties. I tell you that in many cases there are no strong contrast between the treaties. Usually the treaties can be bilateral. We'll see everything. I'm just anticipating something. This can be bilateral or can institute an international organization. Usually, if a country belongs to an organization, it belongs also to the other of similar, let's say, the similar area, ethic area, or political area. For example, almost all the countries are in Western Europe or Central Europe are members of NATO and members of the European Union. There are two different organizations, they have two different scope, but the principles that regulate the two organizations are more or less are the same principle of liberty and democracy. So there is no real contrast. It's different. but it's something that you have to keep in mind. Before we speak about, I make a mention of the International Court of Justice. I give you some short notes about that. The International Court of Justice is one of the organs of the United Nations, and one of its primary function is to judge the dispute between states. The International Court of Justice has two primary functions. The first one is, as I said, to judge the disputes between the states. The second is to give legal opinion to the United Nations. According to the Article 93 of the United Nations Charter, every state member of the United Nations can be party in front of the court. That means that a country who is not member of the United Nations cannot be party is not member of the United Nations, cannot be party in front of the court. For what I remember, there have been two cases in which countries that were not part of the member of the United Nations asked for the judgment of the International Court of Justice. And there was a specific procedure for that, because technically they cannot be part of that. One for sure was Switzerland, I think in 1949 or something like this. I will give you a precise information, or you can search about that, because at the time Switzerland was not yet member of the United Nations, because the United Nations is not always been the organization where we see it. There was a process of enlargement of his number, and also because when they were created, there was a kind of reflection of the Second World War, and there was less nation in the world at the time, because some countries are still vast economical, colonial empires that were partitioned and created new states. The second, I think, was about Somalia, but I'm not sure. Anyway, and for sure, right now, the majority, almost all the countries are members of the United Nations, but they not been always in this way. For example, in 1965, Rhodesia, that is now Zimbabwe, Rhodesia declared its independence from the United Kingdom. Before it was a colonial dominion, and it was not recognized by almost every country, and it was not admitted to the United Nations because it was not recognized. It was not its independence. Going on, the capacity of a member state to be party, it has to be the plaintiff or the defendant. Plaintiff is to call someone in front of the court. It's one call someone in the court. The plaintiff, the defendant, as its very simple terms, is the party that is called to defend itself. So the capacity to be a plaintiff for the defendant doesn't imply that the court has automatic jurisdiction over the dispute between the states. The courts has no true compulsory jurisdiction, and this jurisdiction is based on consent. The parties, it has the state, have to both accept to refer the case to the judgment of the court. So, we have a court. I'm a member of the United Nations as a state. I have the right to be party and be represented in a judgment by the court. But this doesn't mean that in case of a confrontation with another country, a contrast with another country, we refer the judgment. Because first, we have to be both part of United Nations. Second, we have to both accept the jurisdiction of the United Nations. There are some countries that they approve the law, a national law in which they stated that if they are called in front of the court by another state, they cannot refuse. But this is not valid for all the states. And to approve something like this, you need to have a high level of internal democracy, a very strong democratic regime to be that. Because you trust the United Nations, the court, so much that you put your judgment in their hand for something that you can otherwise resolve, even using the force. That's something that, you know, it's happening every day. In this sense, in some way, the jurisdiction of the court reminds the jurisdiction of an arbitration court. Step back. I send you a format about to get information about your knowledge and the law matter, because I could refer to terms that are not familiar for you. Just a very simple note. We have, when we have a conflict between two parties, we can have two types of judges in general. We have a court, the kind of natural judges. You appeal, you go to the court and call the other parties to the court. Or you can agree on an arbitration court that is a private judgment. This is very used in international private law or in the contract law, because, and in some countries, because there are situations in which to go to court can be too expensive, too long, too difficult. So in many cases, when there is a lot of money, especially between companies going on, there's a lot of money that we have to decide about. Both parties prefer to go in arbitration. Let's say a private judgment, both parties choose jointly the judges. There are several courts of arbitration in the world. The most famous is, and the most expensive, is the ICC court, the court of the arbitration court of the International Chamber of Commerce. And this is an alternative because but is something that is agreed between the parties. In some way, the International Court of Justice is a kind of arbitration because it's, let's say, the party agree to be to submit the judgment to the court. Coming back to the starting, talking about the international law order, we face a very complex situation in regard to the legislative source, the authorities that to enforce this law, the judgment, and every other element being part of a legal system. All the elements are heavily influenced by relation on the political and economic dynamics between the states. Because it's really to have matter resolved or regulated between the international law order, it means also that the parties are, let's say, in civil terms between themselves. They don't shoot at each other as soon as they see That would be a quite complicated matter in some situation. So this it's always a part of consent and influence of the environmental system. Therefore, it's very reductive to define international law as the law that regulate the relation between the states. A more correct definition of the international law can be the following. International law can be defined as a law of the community of the state. It is a set of rules that arise from the cooperation between states and rules that are placed above each of them for mutual consent. So this is a strong element. Always they come from cooperation, agreement, and mutual consent. A little historical digression. When the international law was born, from a practical point of view, international law is old as mankind, considering that one of the key composing elements of its key composing element are international treaties, and its recipient are the state. History recorded treaties between territorial political entities since the time of the Assyrian, the Egyptian, the Hittites, and later the Greek city-states, the Roman Republic, its enemy like Carthago, and for all the ancient and medieval ages. The first treaty recorded in history is the Treaty of Kadesh, that acted after the Battle of Kadesh between Hittites and Egyptians. It's a copy of that. It sounds something very remote, but a copy of that is kept at the United Nations Palace because it's the first symbol of diplomacy acting over a confronting powers. At the time, Egyptian and Hittites they were the superpowers of the time. They confronted in Kadesh in Palestine in a very bloody battle. We consider that it was a battle of several thousand of men, probably around 40,000-50,000 between each side on each side. That for the time was absolutely huge. It was won by the Egyptian, but it was not an easy victory. And at the end, they reached this treaty that, aside to state a non-belligerent relation between the two countries, they create also a kind of alliance, because there was an agreement of mutual support in case of third parties invasion. Another interesting element of this treaty, there was also a marriage agreed between the daughter of the king of Hittites and the pharaoh. But there were also two other points in this treaty that I think are interesting because they reflect something that happened later. One was the recognition of internal sovereignty of each of the two superpowers. Basically, Egypt accepted of not interfere in the internal matters of the Hittite kingdom, and the Hittite kingdom do the same. Each of them is they accept to not interfere, and they go even further, because each of them was bounded to give to the other the dissidents that found refugee at his court. So the dissident of the Hittites that were refugee at the pharaoh court were given back to the Hittites, and the Hittites did the same. It is a kind of sound like a cruel matter, let's say, cruel measure. And this is quite modern from a scientific point of view, because it's anticipation of the Westphalian principle that we talk in a few minutes. I will make a note. This is my personal opinion. So take it for granted. You can open disputed. You can have different thought about that, and you will not find for sure in a textbook or in a research. In my personal opinion, despite that we always have treaties between nations, the concept of international law, as we consider it, is closely linked to the concept of democratic state. We have plenty of treaties in history, from Kadesh to the recent days. Let's say the modern era, the stop before. But and these are expression of international law, because the treaties produce international law, international rules. But in my personal opinion, only the treaties between democratic nations were real expression of international law as we express it. I say so because the authoritarian regime and the absolutist monarchy always considered the state as a personal property of the rulers. The state, in the end of the kings, normally existed as a mass, like a mass of territories, from which you can take a piece and to which you could add another. Of course, we have even before, in any time, from a certain point in history, we start to have national entities. We have a kingdom of France, we have a kingdom of England, we have Germany was a different matter, but we have a kingdom of Spain or several kingdoms of Spain. But this kingdom were we have a nominal existence. Nominal existence. In which sense? For example, France. Part of France was part of the Kingdom of England for dynastic rules, because the Aquitaine, Gascogne were being inherited by a king of England, because his mother was the Duchess of Aquitaine. Some part of France were nominally under the rule of the King of France, but the Linguadoc, the Midi were under dukes and nobles that were almost for everything independent. So, and the national states, the territory composed the national state, were like private property. A king can give a castle, a territory, a county, a dukedom to a certain person and take it away. He was the ultimate owner. He has, let's say they were geographical rulers, and the title belongs to the geographical area, but everything was his own, and he considered like his own. It was about this, I think it was emblematic, a phrase said by a king of France, the Sun King, who said, "The state, c'est moi. I am the state." And you think that This concept is what caused, in the last 200 years, the democratic revolution and changed the world. Because until this point, until the French Revolution, the American Revolution, the king considered himself the owner of everything. That's why it's difficult to consider a treaty between two kings like a treaty between two nations that produce international rules. Under the slide, the treaty between kings look like more as civil law contracts between neighboring landowners to settle the dispute on property borders, cattle pasture, and use of springs. We are in the same, because that was the mindsetting of the king. The mindset of the king and the one of their subjected, like to duke or duke and a count or even small nobles, were the same. Everything is mine, and I dispose of everything like I want. For the modern experts, the starting of the international law rule is the Treaty of Westphalia. The Treaty of Westphalia is in this way, or Peace of Westphalia, is considered the date birth of the modern international law. It was signed in October 1648, and it brought to the end to the 30 Years' War. That was one of the bloodiest wars that we have in Europe. The Treaty of Westphalia is considered to start of the process that will bring the development of the modern concept of state, introducing the concept of national sovereignty. According to the terms of the treaty, each country has exclusive sovereignty of its own territory, and the national sovereignty cannot be violated for no reason by other states. It is based on the modern international system of sovereignty of states, which is recorded also in the Chapter 1 of United Nations Chart. So it's the Westphalian principle that, or Westphalian system that I was talking before. And you think when it comes, so how far it comes. It's from 1648 and is still mentioned in the United Nations Chart that was drafted and signed 300 years later. Why is this? So this principle was introduced in this treaty. Because, as I say, the 30 Years' War was a very bloody war. And it was, because it was, aside to be a war between states for political reason, for dominance reason, was also a religious war. It was a war between Protestants and Catholic. It was not always clear, the situation, because not all the Catholic states fight together and not all the Protestant states fight together. For example, France at the time was a Catholic kingdom. Actually, they have always whipped out all the Protestant minority. The prime minister was a cardinal, the famous Richelieu, but he fought with the Protestant, at least for the last part of the war. What caused the war? The interference of the state in the matter of the other state for religious reason. That was the starting of the war, because some states started to mess in the other state business because a minority, a religious minority that was keen, was similar in belief to the belief of the first state, of the acting state, was subjected to kind of persecution and so on. And this sparked this war that spread all around Europe I think that for the time, the 30 Years' War is considered the real First World War. And as I said, it was terribly bloody because there were massacres, there was huge battles. In particular, there was a historical fact that signed the conscience and the thinking of all the European people, and touched not only the politicians but also the military. That is, talking about war is a huge thing, because military are used to violence, are used to see the worst things and everything a person should never see. There was the sack of Magdeburg. The sack of Magdeburg was Magdeburg was a city in northern Germany. It was sieged. It was captured. Basically, 20,000 people was killed. Only a few thousand fled, and 1,700 buildings on 1,900 were burned to the ground. This was something bloody epic, something shocking, even for the time. And it caused, this create a kind of not written rule between the military that from that point on, basically they have a gentle agreement to spare the civilian population from unnecessary pain, unnecessary destruction, and unnecessary violence. And this was a rules that was more or less respected by all the military until the First World War. The First World War in some way changed everything. But until the time, and so you think that the impact that this war have on the mind and on the imagination of the people and the generation following. I tell you, just to pick, there was at the beginning of the principle, the unwritten law of created by the sack of Magdeburg was still so strong that at the beginning of the First World War, there was a proposal, a democratic proposal, to limit the war to Europe, not involving the colonial dominions, not involving the area that was not directly affected by the war. That was basically a European war. The principle of and this principle is still in the chart of United Nations and still respected for now. I see is 3 o'clock. So if you want to make a 5-minute stop, we can do it. Or you want me to go on? No. I see some, okay. So the principle established by Westphalian system has been unchallenged until the end of the Cold War. So, even during the Cold War, the Westphalian principle was still enforced. It was accepted by the United Nations. And at the point that the United Nations were not able to intervene in the matter, which are exclusive domestic affairs of the single state. But even during the Cold War, of course, there were secret wars, there were spice wars, but even during the Cold War, there were not open challenge to the sovereignty, the Westphalian sovereignty, by each of the two blocs. On the contrary, so at the end of the Cold War, on the contrary, the Westphalian system has been challenged more and more frequently during the last 30 years on the basis that it doesn't keep into consideration the principle of humanity and democracy. And it doesn't fit anymore the globalized world at the international challenge like the war against terrorism. This challenge to the Westphalian system was put in discussion mostly starting from the 90s. And one of the most famous speaker about that is former British Prime Minister Tony Blair. And we have a lot to, and this could be true in the sense that, of course, our society evolved. The principle of humanity are being evolved and enforced. And we have also more of that, the principle of democracy. Create a world that's completely different from the time of the Westphalian Treaty. But, and so, this approach can be shared, but until a certain point, because it can create some serious problems. In the sense that any state that thinks that they have a minority of the people in another country that can be mistreated, have an excuse for a military intervention. Some military, and we see a lot of this military intervention in these days. It's one of the most famous is what happened in the Kosovo. The Kosovarian people were, let's say, a ethnic group related to the Albanians, if not totally Albanians. They were mistreated by the Serbian, and at a certain point, the international community, the NATO, they was started to push that for the end of this mistreating, for a democratic evolution of the situation, for the declaration of autonomy, and so on. And at the time, one of the most prominent champion of the Kosovo cause was exactly Tony Blair. And it was a case where, of course, a Serbian will never agree on that. Maybe there was a degree of reason in what was happening. Maybe there was too much brutality because actually Serbia was heavily bombed. And unfortunately, I don't know if you are familiar with geopolitics, but the Balkan situation and the tension between the Balkans countries are always a very complex matter. So it's very difficult to establish a point of a correct point of view. But this is the same principle that was invoked by our enemy to invade part of Georgia and now to invade Ukraine. I say our enemy because my wife is Ukrainian, my kids are Ukrainian, so I feel deeply involved in what's going on. So basically, and in one case, there was some degree of reason for a military intervention in another country's matter. Then we have cases when there is no reason for that. There was absolutely no reason for that. So we have to be always very careful in judgment, and we have always very careful in taking care of all the elements that we are on the table. Talking about international law, we have to keep in consideration a strong difference and a quite common confusion that happen when you use the terms international law. International law should not be confused with international private law, also called more properly conflict of laws. Conflict of laws is the set of rules according to which a national legal order decides to apply the national domestic law or a foreign law. This body of law is part of the national domestic law of each single state. The function of the conflict of law is to guide the judges to decide in regard to a case between companies or private individuals that contains transnational elements. We have various transnational elements. They can have, they will say, anyway, transnational elements. And with the conflict of laws, we have to decide if the mentioned case is under the national jurisdiction. So first, if with the international case, I am a judge, I'm in the power to decide it or not, or the case should be referred and submitted to a judge of a different jurisdiction or different country. Second, if the national foreign law should be foreign law should be applied, because in many national legal orders, it's possible for the judges and needed to the judges apply not the if they have the jurisdiction to judge on a case, they have to judge on it not on the basis of the national law, but in using the law of a different nation for a reason or for another, because this nation is bounded in some way to the case, to the situation, or because it's been chosen by the parties. Because according, for example, you make an international contracts, you could decide, for example, from we can have an Ukrainian with an Ukrainian companies and an Italian company, you can decide not to apply neither the Italian or the Ukrainian legislation, but you can choose as a law of the contract, let's say the Swiss legislation or the British legislation. And in this case, usually when there are this type of cases in contract, the judgment that eventually emerge on a conflict on this contract will be judged by arbitration. But it could happen, I see a contract that was judged by an Italian court between an Italian and a German company, who has the German law as a law of the contracts. And the Italian judge has to apply the German legislation. As stated before, each legal order has a section of law dedicated to the conflict of law. Each legal order has also its own criteria to determine the connection factor between the single case and the foreign laws. This connecting factor could be the citizen or the residence of the individual involved in the case, the place where the contract or the agreement is closed, the location in which the real estate property is located, the place where the contract can be executed. The connecting factor can be different also in regard to the interpretation or approach of the different national legislation give to the same elements. I explain a little more about that. First of all, we can have international connection, transnational cases for in any type of application of the law. We can have on the contracts, we can have it on the family law. For example, a divorce between two people of different nationalities. The succession, if, for example, a person have one nationality, is living in another country, as assets in the other country, and there is a dispute on his assets after his death. We can have also third party in the contract, because we have parties, for example, international sale, international service contract, and so on. Also for the four, and these are elements that create the connection between the application of one national law or another. But aside from what is we can call an objective connection, objective elements, like, for example, the nationality or the place of residence of one of the parties. I call it objective because it's adaptable, that if I have a British passport, I am British, or I live and I have resident and taxpayer in Ukraine, I'm a resident taxpayer in Ukraine. This is out of doubt. Especially in the contracts, there are legal elements that can be interpreted in different way. Because, for example, I speak regarding a conflict over conquest. In some national legal order, a contract is closed just with the meeting of the wishes of the volunteer of the parties. We agree, we shake our hand, we have agreed on to close this contract, and the contract is closed. There is the written form is just to prove the existence of the contract. But the contract is not, the existence of the contract do not belong to the written form. It's just to show that it exists. There are other legal systems in which you have to physically sign the contract. And any meeting of respective desire, respective wishes, respective volunteer that came to agreement are not bounding until the contract is physically signed. That is a huge difference, because if we consider when we met, we shake our hands and we say we agreed, and we consider the moment when we seen, we can have two different locations and two different completely situations for the closing of the contract. So not only we have objective elements that can create a connection, but also legal interpretation. Short note about the conflict of laws in the Ukrainian legislation that I think for you it can be a kind of useful. Even Ukraine has a section dedicated to the conflict of laws and its legislation. This section is composed by 4 elements. There is a law, the law of the private international law, the law of Ukrainian international law is the number 2709 fourth, approved June 23, 2005. There is the Article 10 of the Civil Code of Ukraine. There is the Article 3 of the Civil Proceeding Code. And there is the Article 10 of the Rule of Law and Legislation under which the court rules the cases. I put aside the Ukrainian law of conflict Ukrainian law on private international law, because that means to change the subject of the course. It will be going to the private international law, and I think that you already have some example course about that. So I will do the job of other people in the worse than them, for sure. Let's give a short examination, brief examination to the article of the Civil Code, to the article of the Code of Procedure, and so on. Article 10 of the Civil Code stated as follows. Paragraph 1. A current international agreement regulating civil relations approved by the Verkhovna Rada of Ukraine is part of the national civil legislation of Ukraine. Great principle. In the sense, this is why I want you to read this, because this is a recall of foreign element, the treaty, and this gives the importance of their international agreement inside the legislation of a country. Paragraph 2. If a current international treaty of Ukraine concluded in accordance with the procedure established by the law contain other rules than those established by the corresponding act of civil legislation, the rules of the relevant international treaty of Ukraine shall be applied. Other important principle. With the first paragraph, we recall the international agreement and the treaty as part of our legislation, of Ukrainian legislation. Paragraph 2, we establish a supremacy of the rules of the treaty over the normal laws. So the treaties became a special law that is able to overcome what the national law says. It's another important, very important, important principle. Article 3. Okay, sorry. Sorry, I'm lost. Article 3 of the Civil Proceeding Code. Paragraph 1. Civil proceedings shall be conducted pursuant to the Constitution of Ukraine, this code, the law of Ukraine on private international law, laws of Ukraine defining the specific and certain category of cases, as well as international treaties ratified by the Verkhovna Rada of Ukraine. We are in the matter of proceedings. Again, we have as the source of law to identify the jurisdiction, yes, and how the judgments have been to be conducted. Constitution of Ukraine, the code of civil proceeding, the law of Ukraine on private international law. So the law that we mentioned is placed is introduced in the civil proceeding part. The law of Ukraine defining some specific cases, so the special law, and the international treaties. Again, before the international treaties can be part of the source of law used for decide a civil case. In this case, the treaties are called as a source, as a proceeding law. Paragraph 2. In case an international treaty ratified by Verkhovna Rada of Ukraine defines rules other than those specified by this code, the rules of the International Treaty of Ukraine shall apply. Again, as before with the civil law, even in procedure, the rulings of the treaty, it's overcome the normal legislation in terms of civil proceedings. So this is another important element, pivotal element. Of course, these rulings taken by the treaty, brought by the treaty. Article 10 of the rule of law and legislation under which the court rules the cases stated as follows. When considering a case, the court shall be guided by the principle of the rule of law. The law shall consider cases in accordance with the Constitution of Ukraine, the laws of Ukraine, the international treaties that Verkhovna Rada of Ukraine agrees are binding. Third code of law, and now we have again the treaty approved by the Verkhovna Rada, included as a law, at the same level of the laws of Ukraine. Paragraph 3. The court shall apply other regulatory acts adopted by the relevant bodies on the basis within the powers and the manner prescribed by the constitutional law and law of Ukraine. Paragraph 4. When considering cases, the court shall apply the 1950 Convention for Protection of Human Rights and Fundamental Freedom and the protocol thereafter ratified by Verkhovna Rada of Ukraine and the case of law of the European Court of Human Rights as a source of law. These are in a different perspective, but it's equally important because before we recall it treaties, we recall it law, rules. Here, we recall it principles according to which the decision should be taken and the state should act. That is something, and if also this coming from abroad. And in this case, we will see more in detail later. There are principles that coming exactly the base of the international law. Paragraph 5, the court shall apply the rules of law of other state if it is provided for by the law of Ukraine or international treaty that the Verkhovna Rada of Ukraine agrees is binding. Again, we remark a third time that the law of the treaty should be applied by the Ukrainian court. Comma 6, 1.6, if the court concludes that the law or the other legal act contradicts the Constitution of Ukraine, the court shall not apply such a law or other legal act, but shall apply the norm of the Constitution of Ukraine as a norm of direct effect. This is, in this paragraph, the international law, the treaties, are not mentioned. But it's equally important because it puts the limit of the application of international treaty of the foreign law. So before that, in the other point, in the other statings of the other, even of the other corpus of law, we have the legislator who stated that the treaty and what is included in the treaty has the same level of power, the same position of the Ukrainian law. Here, in the negative, they create a limit to this application. That is to be compliance or not to compliance with the Constitution. That is a fundamental. This is fundamental in any democratic order. At this point, we have to make a comparison for what he said. So the private international law or conflict of laws and the international law, that in this case we will can define to be more clear, like public international law. In summary, we have the proper international law that we can call public international law, and we have the private international law. Public international law governs the relationship between the subjects of international law as the states, while the private international law addresses the private law rights of natural or legal persons that are the subject of the authority of the mentioned state. So, in theory, we have two different levels. The public international law talks to the state. The private international law talks to the citizen, to the entity, which are subjected to the state. Public international law applies to the subject of international law, such state and international organization who consent to be governed by it, while the private law applies to the member of the national community who are bounded to be governed by it as a member of the specific mentioned community. Again, we have two levels, two different situations. In the public international law, remind what we said until now. In the public international law, we have a state that as a subject, states as a subject, but states that agree to be governed by this law. In the private international law, we are subjects of the state that are bounded to be governed by this law, because this law is part of the national law. And as a citizen, as an entity resident or incorporated in that country, you are bounded to follow the law of this place, that place. So it's two different, completely different perspectives. One, we have subjects who are willing to submit to the law. In the other subject, they are obliged to follow the law until the law is changed. Therefore, we can speak about international law and private international law. When we speak about private, we do not speak about two different branches of the same body of law, but we are talking about two separate law orders. They can interact and to a certain level, but they are always two separate law orders. This is an important concept. When we talk about public international law, private international law is not two branches of the same order. They have relation, but they are definitely separate. We can say the relation is more that the public international law influence the private have an influence on the private international law, or give instruments, create instruments for influence of other national legal orders on to interfere, to be integrated in the private international law of a country. But they are two different systems. Now let's talk about international law and international sovereignty of the state. The interstate nature of the international law is clear and evident by its primary scope, that is to regulate the relation between the states. It's also evident that by the instruments that we have met so far, like the international treaty. So it's clear that what is the scope of the international law. This could make us think that the use of international law is confined with the limit of diplomacy, the diplomacy word, the diplomatic action, and the transborder relations. Therefore, we can also reach the conclusion that international law regulates only the external sovereignty of the state. Now we have to introduce a concept. There is sovereignty, internal sovereignty of the state and external sovereignty of the state. Internal sovereignty of the state is what is managed by the national law order. The external sovereignty is, of course, in relation with the other state. Instead, the reality is different because there is a flow of content coming from the international rules that impinge upon the internal sovereignty of the state, even on a daily basis. Because, as I say, there are two different systems, but there is a flow of principle that coming from the international law and go to the internal law. The example is, I go up. It's the comma 4 of the rural legislation that recall the apply of 1950 Convention for the Protection of Human Rights and Fundamental Freedom, and the case law of the European Court of Human Rights and Source Law. This is a clear example of a flow principle from the international law to the public international law to the private international law. So we say that, as we say, the reality is quite different. There are multiple examples of influence of international law in the domestic jurisdiction of the state. The first you already see, the international body of rules on human rights. The traditional international rules for the treatment of violence that forbid arbitrary or discriminatory treatment of the foreign individuals and companies. Because at least this is a very traditional, is something that is connected to the tradition, but in no state there can be a code or a law that discriminates two subjects in front of the law just because their origin, because we can have law that establish rules. For example, to make a clear example, if you have to do a simple you have to pursue a certain professional activity or business activity, you should have a local license. But if I am a foreigner, legally resident, I cannot be forbidden to get this license. The other elements of influence of international law in the jurisdiction of the United States are in the international rules on treatment of foreign state, their official and international organization, from which descend the diplomatic immunity and the extraterritoriality of the diplomatic offices. There are rules internationally recognized regarding the respect of the states. So you have, as we say before, each state has its own authority, sovereignty. They have each of them. They have its own dignity. From that, it came the respect of the diplomatic body, just because representing the state, and from that the rules to be protected. So they cannot be put on trial. They cannot be subjected to discriminatory procedures and so on. Other element of influence of the international law in the domestic jurisdiction of the state are the international environmental rules and agreements, the commercial rules and agreements, the international customs duties and import agreements and import barriers. You think that this is, I think, is quite important, because I know that the university is especially focused on financial matter, on custom matter. When a custom officer always faces itself with matters that are influenced by international law and through the treaties. We are full of treaties dealing various aspects of our economic way of life of our countries. And for you, in the future, there will be more, because Ukraine applied to enter in the European Union. The European Union, basically, I have a personal experience. I tell you just a small, just a short story. About 25 years ago, I was working in a very important firm, and we have the duty to, let's say, reform the national way system, Italian national railway system, according the antitrust principle established by the European Union. I was very young. The chief of the team was the founder of the firm that was a huge person of huge importance, a great lawyer and university professor. He personally took me the files, and there was, let's say, 3 files big like this at the time. At the time, we used newspaper over computer. They were all European Union decision and recommendation regarding the management and the way to manage the railway transport and the other way of transport in the EU territory. I saw that and I understood that day that the Italian parliament on the economic matter doesn't count anything anymore. But it's not a bad thing. The most important is to have good representatives at the European Union, because if you want to have a union that functions, if you want to protect ourselves, and we join together to protect and prosper together, we have to do things that can be harmonized between all the countries. It's important. I think for Europe is the only way to survive, because Italians are 60 million, Ukrainians 40 million, Germans 90. We face countries that are billions, half a billion, with an economy that resemble in the size, the numbers of people living there. No European country can survive alone to the challenge of the next centuries. As I make a quote of, let's say, Pop Hart from every given Sunday. We rise together or we die together. There is no other way. Of course, many rules coming from the international law to the domestic legislation need often to pass through domestic legislation, act, or national administrative conduct. But still, their content belongs to international law. So, European Union make recommendation. It's rare that they issue law in this sense that it can be applied directly by the state. But this recommendation became law in the national parliament, but the content still belongs from the international law. In light of this, a more contemporary approach to international law states that the individual is indeed the subject of international law and the owner of rights and obligations in the international area, particularly in the areas such as international human rights law, international criminal law, and international humanitarian law. So, to close this lesson, of course, there is a basic principle according which the international law is the law of the state and the private international law is the law of the citizen of this state. But now there are some theories in which we are reaching the point that even the single individuals subjected to the authority of the state, at least in some matters, are directly subjected to the principle of international law. And for now, I think I have told you enough about this matter. How many of you still it's still the same number. So I don't lose anything, any one of you. Okay, you will receive the form with questions that you have. I think it's better that you think about what you listen. If you have doubts, maybe you take a note now and you can send me the format, or you can send me directly an email about what is your doubt. And as I said, if think something concrete, interesting, it could be a good matter of discussion, we can talk even public in the following lesson. It's all for now. I thank you again for your attention. I hope it was interesting. I hope that I don't push you to sleep, and we see us in a month. And take
Thank you for
care.
this lecture. We appreciate it.
Thank you very much.
Thank you so much.
My pleasure.
Thank you so much, and see you next time.
See you.
Thank you. Goodbye.
Next time.
Bye.
Nice to meet you.
My pleasure.